Well, folks, I think we'll go ahead and get started.
Yes, you could.
Our process should take about an hour and a half, and we'll take time for a break there in the middle. I want to thank everybody for coming on behalf of myself, Beth, Kathy, and the Tribunal staff. We thank you for all your support of us and your work out there in the parishes and following up on all of these cases that have come through over the years. What I want to do today is talk about we need to understand the basic theology and the process behind the formal annulment procedure and what parts have changed in that. And then we'll, of course, go into the new, shorter process that Pope Francis established just a short time ago. Keeping in mind, of course, that the new law doesn't take effect until December 8th, but we can start laying some of the groundwork now. The first thing to remember, of course, is that the whole thing that you heard in the news is not a get-out-of-jail-free card. Father Paul?
Yes, it doesn't come to December 8th, so somebody starts one now, then continues the whole process, or can
The way we're starting them now is that the law states that decisions rendered on December 8th follow the new guidelines. So we can be writing the decisions, gathering evidence now, but the decision will be held off until December 8th.
so we could use this new paperwork.
You can start using it right away, yeah. Right. The new process still requires that we be thorough and have a clear understanding of the facts of each case. So a petition that is manifestly false or frivolous or lacks any evidence can still receive a negative decision. Chiefly when the tribunal renders a negative, it's because we got little cooperation from the parties, or both sides gathered their own witnesses who just lied about each other, or the marriage happened so long ago that no witnesses exist who can speak about it. Generally, we need to have the ability to show some sort of proof that the consent did not take place as the Church understands it. Your next slide, of course, takes us to Matthew 19. Matthew 19 is where we have our beginnings of the theology of marriage. Of course, you could look at the Old Testament too, but we'll hear from Jesus. Now it came to pass, when Jesus had finished these sayings, that he departed from Galilee and came to the region of Judea beyond the Jordan. And great multitudes followed him, and he healed them there. The Pharisees also came to him, testing him, and saying to him, Is it lawful for a man to divorce his wife for just any reason? And he answered and said to them, Have you not read that he who made them at the beginning made them male and female, and said, For this reason a man shall leave his father and mother, and be joined to his wife, and the two shall become one flesh? So then they are no longer two, but one flesh. Therefore what God has joined together, let not man separate. They said to him, Why then did Moses command to give a certificate of divorce and to put her away? He said to them, Moses, because of the hardness of your hearts, permitted you to divorce your wives. But from the beginning it was not so. And I say to you, whoever divorces his wife except for sexual immorality and marries another commits adultery. And whoever marries her who is divorced commits adultery. His disciples said to him, If such is the case of the man and his wife, it is better not to marry. Very interesting and challenging statement from our Lord. And the moral and biblical theologians have discussed what sexual immorality means in this context. But what it comes down to is our Lord's prohibition against divorce and remarriage. I still have people come to me that say they haven't been to communion for decades because the priest told them that divorce was a mortal sin. Now that's not true. The divorce and remarriage is where the problem arises, but we have to understand that divorce does happen, but it's when people choose to remarry that we get into the great difficulty of allowing people forward for communion. Now many priests will typically hear the story when people come in for the annulment that they don't think they need to do it because it's just this human process. It's something that the priests and the bishops invented just to make my life miserable. Well, it's always good to go back to our biblical roots and say, well, we as a church are required to pass on those teachings that Jesus had and to bring people to and set a very high bar for consent and married life. And when he tells us this teaching on divorce and remarriage, it's something we all have to take very seriously, especially our priests and deacons and whatnot. And so when someone comes to us, they say, well, what do I do then? If I have to go through this process, but I don't want to do it, what do I do? Well, let's go to the next slide. Your meeting with a parishioner is very important. Step one. This meeting should be friendly and supportive. Encourage the petitioner to be open and honest about their story. Reinforce the confidentiality of the process. Remind them that there are biblical and sacramental reasons for having to investigate the marriage. Please leave your own opinions about the process at the door. Ultimately, they will not help the person you are counseling. It is better to know the law and get it to work for you, not against you. I had, when I was in the parishes, a petitioner come after me and say, when I was describing the process, they were getting very angry about all the things that happened in their marriage, and it just, Father, we should just get this over with. And he just got mad. And I said, I'm glad you're mad, but it's not going to help you. What are we actually going to do to move forward? If they are frustrated with the process, encourage them to get smart. The advocate's attitude about the process can sometimes make all the difference. And again, if a person goes to talk to their priest and the priest says that this is just a formality, I don't agree with it, it's kind of dumb, you're going to get a bunch of questions you don't want to answer, well, you're already setting the stage for the failure of their case. I'll get notes in from petitioners that says, my priest said I didn't have to do this, or my priest said that this process isn't worthwhile. Well, guess what? You really hurt their chances of getting their enrollment through. Always take the positive aspect of this. Talk about the healing ministry. Talk about dealing with these old hurts and putting them behind them. Talk about entering into the sacraments anew with a clean heart. All those are the sorts of things that can put people in a much better mental attitude and bring the case to a positive conclusion. Step 2, of course, are all of the documents. If the shorter process is all about quickening the formal process, it's good to make the formal process quick as well. This is one of the chief areas where we lose time in the process. Make sure that all the documents are gathered quickly from approved sources. Get the first, middle, last, and maiden names and full addresses of the parties. Google is, in the white pages is a great help for this. You can do all sorts of searches and finding all sorts of addresses on the internet, and that can help you find where these people are. A current baptism record with all the notations from their church of baptism. The certificate of marriage, you can always get a copy from the courthouse. The divorce decree, not the stipulation agreement, and not just the first and last page. We want to see the whole thing. The identification of witnesses and your mandate. Again, this is one of the things we're always sending back because the person filled it out on their own and didn't have their advocate sign it, accepting their mandate. So make sure that's signed by yourself and the petitioner. The documents should be gathered from all previous marriages, not just the ones that the parties think count. So if you're halfway through the annulment process and they start joking about the time they gave vows before Elvis down in Las Vegas, you need to investigate that one as well. And even if it was in a very short, brief ceremony, if there's a document somewhere or if they gave consent, it needs to be investigated. The annulment process, step 3, is the short history. After you've taken time to get to know the petitioner, ask some questions about the marriage at bar and encourage the petitioner to begin filling out the short history. This is where your bedside manners will be very important. Be calm, be happy, be supportive. Let them know that these are some very tender memories and you're going to do your best to take care of them and minister to that person. Do not leave any space blank. If the party states that there were no problems before marriage, keep asking questions to draw out the answers. Sometimes the memories will be buried where the person is still looking through rose-colored glasses. That brings us to the petition, which we made a few brief changes on. And the first white page is where the short history is. And hopefully all of you have seen this. And that first big section where it says, prior to our wedding we had these problems. Don't ever put nothing in there. Don't ever leave it blank. Really ask them about what that means. Chances are they don't have the same degree of theological training that all of you had, so it's good to ask some more loaded questions and say, well, what did your consent really mean to you? When you said those words, what was going through your mind? Did you understand that the church teaches about an openness to children, a commitment to fidelity and unity, a commitment to permanence? Were those really things that you had taken time to appreciate at that time in your life. Chances are, when you're 18 years old and making those promises, that might not be fully formed yet in your mind. The short history should be written from the perspective of the petitioner, not the advocate. Remember that this is that person's petition and not yours. So when they say that our most serious mental problems were, if you say something like, he was mean to her, that's not a petition. That's your description of the events. It needs to say, he was mean to me, or she married me for my money, or any sort of those other crazy things we hear in marriages. It needs to be from the petitioner's standpoint, because this is the person asking the bishop for a favor, is ultimately what this comes down to. A favor to have their case heard.
Father, do you want to mention about it not being inflammatory at this time?
Sure. So one of the important things to remember too is that this needs to be fact-based, not emotion-based. And what that means is that if they go in and tell all the dirty laundry at this stage and how awful the person was, those aren't, being a jerk or being mean isn't necessarily a grounds for annulment. They need to be factual about what really went on in that marriage. What was their state of mind? Because if it's really inflammatory, if it's accusatory, if it's angry and emotional, then the other party is going to respond in kind, and now you get this back and forth, tit for tat sort of argument going on, and no facts ever come out. So that's important to understand.
In that case, the petitioner might have been abused through alcohol or physical abuse and confessed that in her preliminary statement or his preliminary statement. And that's inflammatory to the other party.
It can be, but if it's fact-based, that's fine. And if the person says he was arrested and put in jail for abuse, or many witnesses saw him beat me, or she was drunk every day we were married, just state it just like that. And a lot of times when it's done just very fact-based, just a few lines, the other party will come back and say, yes, I admit to that. But if it really goes on with all the inflammatory type statements, it's going to have a negative response.
I know some, in the problem fidelity, say, well, we get a problem fidelity, not that she was a blank, that had hinged on a heel and fell off everywhere after she met. I mean, they state the facts, we don't state inflammatory terms, because that was,
right, so the name calling and that sort of stuff is where you can get into a problem. But it's amazing how often people just come back with their next statement and say, yes, I admit to that. I was in a different place in my life and I'm better now. They'll say all sorts of different things about that. So now on the grounds, before you start just checking off all the possible grounds on the grounds page, ask the petitioner which of them will actually be able to be proven before the court. So if you look to the next page on the petition, you have all these examples of grounds. I'm just going to go through very briefly, and I apologize if this is a review for everybody, but it's always good to really keep in mind what these really mean. Because many of these might have been present in the marriage, but it only matters if they can prove it. Can you get statements from witnesses? Can you have official documents that point to some of these? Generally, two people must be able to state something before it is considered factual in the court proceedings. The old saying goes, one witness is no witness. That which can be proven with official documents is most helpful. Take time to go through each potential ground with the petitioner and ask specific questions about the circumstances of the marriage bar. Any grounds that are checked should also then appear in the short history. So sometimes the short history will say something like, our relationship was great, but then on the grounds page they check off infidelity. Like, well, where did that come from? It's got to be somewhere. So the grave lack of discretion of judgment means that at the time of consent, the person lacked foresight, insight, judgment. They were young, they were inexperienced, they were severely immature. There was extreme family, cultural, or other pressures, premarital sex, or pregnancy that kind of put them in this mindset that they weren't able to really judge what was going on around them. They kind of went on autopilot. And they were told by everybody, you got to just marry this person, and they just kind of went ahead and did it. But they never really reflected on their own life or their choice of spouse or anything else, and they really lacked due discretion. Now there's a difference between just being slightly immature, being a little whimsical, being young, that is not the same as grave lack of discretion of judgment. Because everybody, when they're young, is young. And many people get married when they're young. So it's important to really state that whatever these circumstances were, it went beyond the level of mere immaturity and became this grave lack of discretion. It almost becomes like a brief mental illness, in a sense. Then there's the inability to assume the essential obligations of marriage. So because of a psychological reason, at the time of consent, they're unable to enter into the partnership of the whole of life. This is where we often see alcohol, drug abuse, personality disorders, mental illness, those really severe things. And there are two ways this can work. The one is where, because of their mental state at the time of consent, they're unable to give consent at all. Or if they're having a moment of clarity and everything is fine on the wedding day, but then everything collapses for the 20 years after that, those can often stem from similar reasons. But if the person is drunk when they gave consent at the marriage, that could be another one too. But this is where we have to get some sort of a psychological evaluation done of the person to really prove that. The next one, simulation, is where you take a look at all the aspects of marriage and consent, and imagine like a Christmas present with a nice bow on top. And inside you have fidelity, the good of children, permanence, community of life, and sacramentality all in there. It's wrapped up, tied, and then you hand that to the person at the foot of the altar. That's what consent is. However, if a person at the day of their wedding takes one or two of those out, wraps it up and hopes nobody notices, and hands it over, then they have a defect of consent. So maybe somebody was having an affair, where there's fidelity. Maybe they wanted to put children off for 5 or 10 years. That's children. Maybe they thought that, well, because all my other family members have been divorced and it didn't work out, I'll just do the same thing. That's permanence. Or they didn't really intend to work well for the other person. They just married them because they wanted a house servant or someone to take care of them. Or that if they had this strong belief that it wasn't a sacrament, or that there was, when they were validating their Vegas wedding at church, they didn't really think they were taking on anything new. All this Catholic stuff is just a bunch of stuff to make grandma happy. Well, you got to make sure that every aspect of that is present during the consent. Error is often linked with fraud. They're kind of mirror images of each other. Error means that you had wrong knowledge about the other person. There was some aspect of them that, had you known it at that time, you would not have married them. Now, there's no fraud on the other person's side in this case. You never bothered to ask, do you want to have children? You never bothered to ask, are you attracted to me? You never bothered to ask, are you ever going to work? Those sorts of things. There's just an error. And the person was never really maliciously hiding it. They just were who they were, and the other person never bothered to find out. They had error for some sort of reason. Fraud happens when I'm actively changing myself and giving you wrong knowledge. I'm telling you something that is wrong, and then when it comes to light, that forms the basis for the divorce. Force or fear is one we still see a little bit of when family or societal pressure is so severe that the person has no other choice but to marry. This is where force or grave fear comes in. This can also, the light version is the grave lack of discretion of judgment. But say a father is up there giving a homily one Sunday about how all those people who are cohabitating are going to go to hell. Well, then a couple turns to each other and says, oh, we better get married because we don't want to burn for eternity. Well, that can be a force or fear. Now, they're not really marrying each other because it's the right thing to do. It's because they're simply afraid of some sort of punishment, or if someone is forcing them in some other fashion. The condition, you can put all sorts of conditions on a marriage. If somebody says, I'll marry you and stay married on the condition that you make $1 million, or that we have a boy and a girl together, or you have to take me on a vacation next year, or a big honeymoon or something. People can put all kinds of strange conditions on a marriage, and that can sometimes be a validating cause. We we kind of covered invalid convalidation, and there's also other. If you can think of some other stuff, that's always very interesting. But all those grounds need to be well understood. And you just check off the ones you think can actually be proven. Okay. When we start to gather the proofs, it's important to identify sources of information that will help the case proceed. Primarily, this is in the form of witnesses. Witnesses should be people that knew the couple at the time of marriage. Oftentimes, when I get a witness statement that comes in on a case and the person states, I met them 10 years after they were married, I take that statement and put it on the bottom of the pile because it's not very useful. They've got to know the people at the time of consent. Character witnesses are those people who knew the parties well and can attest to the truthfulness of their statement or the lack thereof. The character witness will simply state that this person is an honest person, or this person tends to lie. Sometimes we're looking for one or the other, especially if it's in a case where the person hid aspects of their life, or if somebody doesn't have any other witnesses around, but they need someone to back up this accusation they're making that their spouse was abusive, or something like that. So official documents such as arrest records or other correspondence can also be collected at this time if the petitioner has access to them. So the Iowa Courts Online and other similar websites have great sources of information about what's happened in people's lives, and everything from their arrests to their marriages is all available online now.
Father,
Yes.
do you want to mention anything about when we see confidential statements coming in?
Oh, that's a good one too, yeah. A lot of times people will send in a secret envelope, and then the secret envelope is marked confidential and a big red marker on the front, and it has all the really juicy details of what went on in the marriage. But because it's marked confidential, I seal it up. Sometimes I don't even read them, and I put it away. It will have no bearing on the case because it's marked confidential. Everything that's submitted into the acts has to have the potential to be reviewed by the other party. So anything that's marked confidential, do your best to encourage them to include part of that in their petition or their later testimony, if at all possible. But I don't really need to know anyone else's dirty laundry. I've read enough of it. So, but all that confidential stuff makes no difference on the case.
I think some people put confidential on that because they don't want their partner, their ex-partner, to have any access to that.
Right, and so a lot of times, like I say, if the party comes in later to do their review as the respondent, anything that's marked confidential is never shown to them, but likewise, it's not entered into the case either. I can't use it in my argumentation of the decision. So of course, then your final matters, verify that all the documentation has been collected. And believe me, I don't even like doing that. I've got 4 cases sitting on my desk at home right now, waiting for all the divorce decrees and marriage documents to come in. But you got to have it. Make sure you sign your mandate. Have the petitioner initial the petitioner agreement. We'll go over that in a second. And do not promise a swift conclusion. Be realistic with the person and urge them to be patient. We're hoping that the new reforms will shorten our process by quite a bit, but don't ever guarantee. You know, there can always be problems with the case that cause it to take more time. Now, the 2 petition agreements that are signed basically state that they won't make any Catholic wedding arrangements until they've received the affirmative decision. And also that they will not take any civil action against the tribunal, respondent, or witnesses based on what is said. It's merely an ecclesiastical question.
Is there kind of an implication possibly that they could do a civil ceremony?
You know, if somebody goes and says, Father, I'm going to go do a civil ceremony, do your best to encourage them not to, because you don't want to have to then fill out more paperwork down the road. But you have very little power to control what people do with their lives. You can say, I would prefer that you hold off to your Catholic nuptials at the same time as your civil service. But if someone tells you we're going to get married in the park, that's a pastoral question. Okay, Now, I want to get down to the shorter process. In certain circumstances, a shorter process may be possible. The new law creates an administrative process for annulments that will likely be much shorter than the formal process. The way that they did this really was they farmed out some of the work to the advocates. The tribunal functions as kind of a bottleneck that keeps everything going at exactly the same speed. One case comes in and another one goes out. And we have to go through a long process of collecting the witness statements, giving people opportunity to respond and come in and look things over. And that simply takes time. It takes a year or more for our cases to turn around. However, in the shorter process, we're asking the pastor to collect the proofs at the beginning. The respondent has to agree with using the shorter process, and it's the bishop himself who makes the final ruling. He doesn't write a decision about that. He simply reviews the evidence and then signs a decree. This means that we're moving from a judicial process to an administrative process. Most of you are pastors, and you should well know what the administrative process means. That means I said it, therefore it's done. Okay? And this is how the bishop will act in these circumstances. We're going to go through how this will work. It's very interesting. It raises some interesting theological questions as well. So here is a quote from Pope Francis from the document Mitis. It is thus the concern for the salvation of souls that today as yesterday remains the supreme goal of the Church's institutions, rules, and law, which impels the Bishop of Rome to offer to the bishops this document of reform, inasmuch as they share within the task of the Church, namely the protection of the unity of faith and discipline regarding marriage, the cornerstone and origin of the Christian family. The zeal to reform has been fueled by the enormous number of faithful who, while wishing to act according to their conscience, are too often separated from the legal structures of the Church due to physical or moral distance. Charity and mercy therefore require that same Church as a mother to make herself closer to her children who consider themselves separated. Of course, we know what he's talking about are the people that have divorced and remarried. The shorter process there, I listed the number of things that will shorten this up. What they're calling for first is a single executory sentence in favor of nullity. Now this benefits both processes, chiefly the former. It seemed appropriate in the first place that there is no longer required a double conforming decision declaring the nullity of the marriage to enable the parties to be able to contract a new canonical marriage. Instead, moral certainty reached by the first judge under the norm of law is considered as sufficient. At this time, whenever I render an affirmative decision at our tribunal, it's automatically appealed to the Metropolitan Tribunal. They then take it for a month or two and send it back to us either affirming or denying my decision. What this means is the first judge, once they achieve moral certainty, sign off and say affirmative, that's it. The case is done. Provided that one or either of the parties does not choose to appeal it on their own, they can still do that. 2, a single judge acts under the responsibility of the bishop. The constitution of a single judge, who nevertheless is to be a cleric, is in the first instance committed to the responsibility of the bishop, who in the pastoral exercise of his judicial power is to take care that no laxism whatever is indulged. You can use that in your parishes too. Do not indulge any laxism among the faithful. Right now, we have to use a special provision in order to use a single judge in our cases. Now this enshrines it in law that instead of having 3 judges, you can automatically have a single judge. However, the bishop is supposed to be watching over his judges to make sure that they're not just rubber stamping every case that comes through. This is one of the chief problems that led to the previous reform. The previous reform was adding in the second instance court because some judges were just taking $100, signing their name to a piece of paper, and then say, go get married, and turning their tribunals into annulment factories. Well, we don't want that to happen. So the bishop has to exercise pastoral care over his judges and make sure that they're not just letting anything through.
If it's turned down, do they have a chance to appeal to another tribunal? Because most people are affirmative, they're not going to worry about courts and business. But if one court, let's say, is more the other way,
So if they receive a negative or affirmative, either party can go to Dubuque and appeal. And they'll say that, there's something, there's all different ways you can appeal. You can say that there's something flawed with the decision itself, or they did not give me my rights, or they came to an illogical conclusion based on the evidence. They have to have some reason to appeal it, so they have to say that it was wrong, it was flawed, it was this or that. And then the second instance can either take it or they can not take it. But yeah, they still have that option. It's just no longer automatic.
Is that, this shorter process with the one judge, is that different than the bishop issuing an administrative appeal? Or is this still the explanation of how the bishop does the administrative?
Yeah, my presentation is a little bit mingled because some of these do affect both things. But basically the single judge aspect is the formal process. So the formal process is still there. This is one of the ways they're shortening that one.
Okay. The formal process in the first instance by our tribunal, and if a respondent challenges that at that time, it's on hold until that's resolved.
Right. So you have to. So they'll have, I think, 15 days to launch an appeal. During that time, the sentence is suspended until the second court looks at it. Now, Father Brumfield, you raised something interesting to mind, though. If the bishop makes his administrative decision on that, who does that person appeal to?
I would assume Rome.
Now, it'd have to go
Because
to
every bishop's equal.
Yeah, it'd have to go to Rome, but I'm not sure if it would go to the Signatura or to the Rota or to the Congregation for Bishops. I don't think that's a question that's been asked yet. That's interesting. Yeah, you have to take it one step up above the bishop.
But by the time it gets to the bishop, you've already had the 15 days for the respondent to challenge it. And so the likelihood of that happening is probably remote.
It's probably pretty low, but probably every other year we get somebody who wants to challenge a decision.
But on the short form, though, it says the parties both have to agree to everything grounds before it goes in, so there's nothing to challenge, because we both said this is okay, we both agree this.
All that they're agreeing to, and we'll get to that in a minute, when they agree to use the shorter process, is that they're agreeing that the case can be heard without going to a judge. They don't have to agree that they're going to like the decision. When it comes through, they can still technically appeal it. Okay, so then the shorter process itself, this is where the bishop becomes the judge. In order that the teaching of the Second Vatican Council may finally be put into practice in an area of great importance, it was decided to make it clear that the bishop himself, in his church of which he is constituted shepherd and head, is by that reason himself a judge among the Christian faithful entrusted to him. It is greatly hoped that in large as well as in small dioceses, the bishop becomes a sign of the conversion of ecclesiastical structures. It does not leave the judicial function in matrimonial matters completely delegated to the offices of his curia. This is especially true in the briefer process, which will be established to resolve the most evident cases of nullity. The Second Vatican Council was very big about the bishop being present and active in his diocese. And what we've found over the last 40 years is that very few bishops are involved to a high degree in their tribunals. It takes a lot of time, and the bishops are very busy. And it's not one that many bishops have a high degree of expertise in. So this one is saying that this is a way to bring the bishop back into that process that touches so many people's lives in their dioceses, and is so important. So bringing the bishop in as a judge on those.
And are we talking about the ordinary then?
Well, he's already a judge on the ordinary process, but now they're.
But if there's other bishops in the diocese.
Yeah, but now it's saying that the diocesan bishop is the only one who can act in the short process.
So the ordinary.
What do you mean ordinary?
The bishop in charge.
Oh yeah.
Cardinal George and all the other bishops under him.
Not every ordinary is a bishop. So the vicar general is also an ordinary.
And if then the see is vacant, then all the space is in the hold, so the bishop is.
Well, the question of the vacancy, if there is, I'd have to go look specifically, but I think it said the diocesan bishop or the equivalent. So if there is, someone appointed during that time, it's possible that they could do that. And I know with like the demissorial letters for an ordination, the person who is the caretaker of the diocese can do so after the see has been vacant for a year. So we might be looking at a similar process here.
It's sort of a whole thing for years.
Hopefully we don't go that long.
Now, does that, for example, say, when the time comes Bishop Amos' tender's resignation, he's named administrator to a new bishop who's sent. Because he was the former bishop, does he still have that power to grant these things, or does he have to wait?
So the question is about what happens when Bishop Amos retires. Well, let's cross that bridge when we come to it, because the hope is that, yeah, he'd be appointed as administrator, but something else could happen. You know, it's up to the Vatican to make those decisions. So I'd have to do further research on some of those little questions.
Yeah, but I'm saying, because, somebody's still going short form, in another couple of years, that short form could become a real long form.
Right.
To see what's-
Well, we'll figure that out when we get there.
I just imagine, something you ask the others that I talk about, but just raising questions now before it gets to us.
Yeah. So now we're back to the briefer process. Indeed, aside from expediting the ordinary process for the declaration of nullity, a form of briefer process is designated, in addition to the current documentary procedure, to be applied in cases in which the alleged nullity of the marriage is supported by particularly clear arguments. It has not entirely escaped us that the briefer process can endanger the principle of the indissolubility of marriage. For precisely this reason, we have chosen that in such a procedure, the judge is to be the bishop himself, who, due to his pastoral office, is with Peter the greatest guarantor of Catholic unity in faith and in discipline. So again, with a shorter process, it's the bishop who has to sign off on it, not the JV, not a judge, not just anybody, but the bishop himself. So they're hoping to add a little higher degree of control.
But the bishop himself doesn't have to do all the work that the judge normally would do. I mean,
Right. Probably what will happen is the tribunal will still put a brief together of all the evidence that's been collected with a cover letter. Then the bishop still has to review that and he'll sign it, but we'll do all the work before it gets to him.
I'm going to say, how much time does Bishop Amos have to be able to actually look at marriage cases?
Yeah, we're going to talk about how to start scheduling this, because there's a whole process of scheduling these as well. One of the things that touches all the cases is the rules for competency. So there's only 3 ways now we establish which tribunal to hear the case is in, short or long. First, it's a tribunal of the place in which the marriage was celebrated. 2 is the tribunal of the place in which either or both parties have a domicile or quasi-domicile. And 3, the tribunal of the place in which, in fact, most of the proofs must be collected. This is going to save us some time, because right now, if the respondent lives outside the diocese, we have to contact that person or the JV of that diocese in order to get permission for us to proceed. And if that person lives in another bishop's conference, it's effectively impossible. So if you have somebody who the respondent is living in Mexico or Africa or Europe somewhere, we can't get competency here, even if the petitioner is here and they're ready to go. Now, just where either party has domicile, you can have a case heard. That's going to shorten up our back and forth quite a bit. Because on those cases where somebody lives out of state, you're shaving a month or 2 off of the case just right there.
So in other words, okay, let's say you've got a petitioner here and you find it before. So then you're saying you don't have that reading period and answer from the respondent to get back, or I get them.
Right, if we have the petitioner here in our office presenting a case and the respondent is in Florida, we don't have to contact their JV to get competency. We can just start the case right away. The respondent is still contacted for the case itself, but that jurisdictional issue is resolved immediately. It's important to remember that in the shorter process, the respondent must still be contacted. The defender of the bond is contacted at this time as well. The respondent and defender have 15 days to make a response to the petition. After this 15 days, the judicial vicar will formulate the doubt and decide if the case qualifies for the documentary process, the shorter process, or the formal process. As you know, the documentary process is where we look at legamen or a lack of form, some other sort of thing that can be proven by documents if they weren't married properly in the first place. The shorter process is the one where we have clear evidence at the beginning and we just move to the administrative process, or we do the formal process, which you're all familiar with already. This is where the shorter process is held in law. This is the new Canon 1678. So if you have your canon law books at home, you're going to have to get on the Vatican website and cut and paste the new sections in there. In cases of the nullity of marriage, a judicial confession, this is any statement to a tribunal official where a party says something negative about themselves. So if they're helping the case, that's what this is, a judicial confession. And the declarations of the parties, possibly supported by witnesses to the credibility of the parties, can have the force of full proof, to be evaluated by the judge after he has considered all the indications and supporting factors, unless other elements are present which weaken them. What most people take this to mean is that if the grounds you're looking at is infidelity, and one of the parties says, yes, I was unfaithful, that counts as full proof. It used to be you had to have full proof with a corroborating witness. So the party could say something, but unless you had a witness backing it up, it didn't count. But they do still want to see these credibility witnesses, though, to help out. But they're not mandatory. In the same cases, the testimony of one witness can produce full proof if it concerns a qualified witness making a deposition concerning matters ex officio or unless circumstances of things and persons suggest otherwise. These are professional witnesses like psychologists, marriage counselors, doctors, lawyers, that sort of thing. So the notion of full proof has been broadened to include the statement of a single party backed up by witnesses to credibility. Again, this is another place we used to lose a lot of time, was we couldn't find any witnesses, so we're scraping the bottom of the barrel to try to find people who will respond, waiting and waiting and waiting for something that never comes in. We also want to look at 1683. The diocesan bishop himself is competent to judge the cases of the nullity of marriage with a briefer process whenever the petition is proposed by both spouses or by one of them with the consent of the other. 2, circumstances of things and persons recur, which means make themselves evident, with substantiating testimonies and records, which do not demand a more accurate inquiry or investigation, in which render the nullity manifest. Note that the respondent must give consent for the shorter process, and there must be substantiating evidence at the beginning of the process in order to proceed with a briefer process.
Every now and then, a case where they just can't find a respondent. They've done the search from the system. Does that mean this null and void?
Yeah, if you can't find the respondent at all, you can't do the briefer process. There was actually, I had to take a slide out because it was wrong, you'll see it here later, that many people were thinking in the formal process, if you can't find the respondent, you just mark them illegitimately absent and then you proceed. You cannot do that with the shorter process. You have to have consent from both parties. So then we would just go into the formal investigation if they're not able to be contacted or found. (1684) The libellus which introduces the briefer process, in addition to those things enumerated in Canon 1504, must set forth briefly, fully, and clearly the facts on which the petition is based, indicate the proofs which can be immediately collected by the judge, exhibit documents on which the petition is based in an attachment. Now, what I want to do is probably take a little break, and then we'll go into the documents for the shorter process. Is that all right? Okay, 5 minutes.
Yeah.
Now we're going to get into the good stuff. Okay, well, let's see how best we can do this.
On the brights? No.
We're going to we'll talk about the documents first, and then we'll get into the grounds.
Okay.
The shorter process requires a thorough investigation from the start. The prejudicial or pastoral investigation, which in the context of diocesan and parish structures, receives those separated or divorced faithful who have doubts regarding the validity of their marriage or are convinced of its nullity, in the end is directed to understanding their situation and to gathering elements useful for the eventual judicial process, either the ordinary or the briefer one. The investigation will be developed within the unified diocesan pastoral care of marriage. The pastoral investigation will collect elements useful for the introduction of the case before the competent tribunal, either by the spouses or perhaps by their advocates, it is necessary to discover whether the parties are in agreement about petitioning nullity. All elements having been collected, the investigator culminates in the libellus, which, if appropriate, is presented to the competent tribunal. Now, the next one should have a red X in it. This was where, if the respondent chooses to opt out of the formal process, you just simply continue. But unfortunately, with the shorter process, you have to have respondent's consent. You can't, and silence in this case is not consent. It has to be a verbal or a written statement. But we'll go on to these grounds here. This is interesting. Among the circumstances of things and persons which can allow a case for nullity of marriage to be handled by means of the briefer process according to canons 1683 to 1687 are included, for example, the defect of faith which can generally generate simulation of consent or error that determines the will, a brief conjugal cohabitation, an abortion procured to avoid procreation, an obstinate persistence in an extraconjugal relationship at the time of the wedding or immediately following it, the deceitful concealment of sterility or grave contagious illness or children from a previous relationship, or incarcerations, a cause of marriage completely extraneous to the married life, or consisting of the unexpected pregnancy of the woman, physical violence inflicted to extort consent, the defect of the use of reason which is proved by medical documents, etc. Okay, I'd like to poll the class here, that first one, the defect of faith. Anybody care to take a stab at what the Pope means by that?
Unbaptized?
So possibly unbaptized? No? Maybe.
How about a mixed marriage in which one party of the marriage was not of the Catholic faith and had a different understanding of the whole of life and the sacramental dignity of marriage?
Right, so possibly you have a Catholic and a Baptist, and the
Yeah.
Baptist doesn't believe that marriage is a sacrament.
Yeah.
It's holy and it's good, but it's not a sacrament.
Sure.
That could be a defect of faith, I would think. What about if you have two Catholics who come in who, after they were confirmed, stopped going to church for 10 years and showed up on your doorstep wanting to marry, and you have every reason to believe that they're not going to come back after marriage, they just want to use your church. Would that count?
Could.
Maybe.
I was talking with some of the guys before, during the break, that I would wonder if this is where we might see some of the Pauline and Petrine privilege cases coming in. We have somebody who was married to this non-Catholic, non-Christian person, and although with the Petrine privilege it deals with someone else's previous marriage, that could still be potentially a cause where you think, gosh, I wonder if, neither of them had an understanding of marriage as we understand it, how can it be a sacrament? The problem that canonists have with this statement then is that it seems to set a pretty low bar for annulment, where how are we going to determine if our people have sufficient faith to get the sacrament? If they come in and say, well, you haven't been to Mass in 10 years, you can't get married because you don't have any faith. I don't know if I want to be the one who makes that judgment. Or if we look back then through our parish books of all the people we don't see anymore, we'll say, looks like they didn't have faith. They're all annullable. I don't think we want to get there either. So it almost sets too low of a bar. It has to be something that we can prove. I'm curious to see how this one comes in. A brief conjugal cohabitation, so a very short marriage. If there's an abortion to avoid procreation. Usually we see this in the intention contra bonum prolis, where the people will not have children. They'll contracept. If they do get married, they'll abort. And we see they really did not want to have children. This could be one that is serious enough to apply for the shorter process.
Brief conjugal cohabitation, you're saying that a couple who cohabitates for a short period before marriage, or even a long period?
No, this is conjugal cohabitation. So they've married,
Conjugal.
then lived in the same house for a few weeks or months, and then divorced right away.
Okay.
Now, the premarital cohabitation, I don't know, you could get back into the notion of the defect of faith, where the church states you need to live your life a certain way, no premarital sex, no living together, but they've abandoned both those things, what does that say about their understanding of marriage?
Well, didn't there used to be a parallel between what we required for a couple preparing for marriage, all the steps we had to do, and ensure in response to the fact that they became grounds for annulment if they didn't have those, like some of the questions we have in the prenuptial about, are you the one to be pregnant? It's like trying to get some of those force and pressure issues off the table before.
Yeah, those questions are on there as a formality. Hopefully you've gone through the focus inventory or something else like that to really suss out their true feelings about that stuff. The problem is, like, if I get a libellus that comes in and states that we didn't want to have children, I'll call the parish and pull their prenuptial investigation and say, photocopy that and send it in, and I'll see if they check that off. 99 times out of 100, they checked, yes, we want to have kids. Yeah. So they were effectively lying to their priest at that point.
Well, I realize that, but what I'm saying is, if you interpret defect of faith very broadly, then that means I would have to, on the prenuptial agreement, sit there and now have a restriction saying, well, do you practice your religion weekly? Rather than just using the term regularly, and we vaguely interpret regularly.
Right, so you're asking how would you show faith existing in the prenuptial form?
Right.
And then particularly if somebody was not Catholic, would you ask them any pointed questions about what do you really believe about marriage?
Right, exactly.
Yeah, that's... canon law does set kind of a low bar for what marriage is, because we have to believe that people who live in non-Christian countries still validly marry. Right. Because it was ordained by God. This is why it's so problematic, because now you have an equally low defect that can go right to the core of what people believe. So yeah, that might be something to look at. Beth, make a note on the prenuptial investigation for that. That's a good point there, Farley. The concealment of sterility, contagious illness, children, incarcerations, those sorts of things. We still have that question where we ask them about any secrets that your spouse does not know about you. The unexpected pregnancy, this is where we see lack of due discretion used now. This is one of the more common grounds. We were pregnant, therefore we got married. Those are automatic referrals to the shorter process now. The physical violence, that's not one we see very often. And defective reason. That is the one where we're going to see more like at the wedding itself they were drunk or they were high. We just completed a case a little while ago where the people had been high on meth for a week and then went down to the courthouse and got married. Well, they were still high when they gave consent, and they both admitted to it. Now, in this case, when you're then a priest doing the nuptials, if you smell alcohol in someone's breath, I hope you're already writing that down. That shouldn't be something we just do now, but if you recognize that they're not functioning properly, write that down. It's good to know.
Question over here.
Father Greiner.
When going back and looking at the grounds for which we can use the briefer process, so for all these things, both parties agree that this was the issue. You have proof.
Let me walk that back real quick. Both parties simply have to agree to use the shorter process.
But they don't have to both agree on the grounds.
No, they could have completely different grounds or disagree on that.
Okay. But when it comes to actually providing evidence of these realities, for example, the extraconjugal relationship, having an affair at the time of the wedding, one spouse just has to admit that. And again, you don't need another witness under the new rules.
Right.
Then that case is pretty much
closed. Well, hopefully we would still try to get corroboration if we can. We would still try to get character witnesses if we can. Then it'd be up to the bishop to decide if he wants to grant the annulment based on the statement of one person. But if the other party has already consented to use the briefer process, it's likely that he would, because they've consented.
Wouldn't you have to verify that do some type of check to make sure the person, otherwise I could, couple could walk in hearing that's the story. Oh yeah, I'm gonna lie and say I had an affair, in the process to get the Catholic Church to give me a speedy annulment.
Right.
I mean, what's the difference between that and handing the priest, $50 bill to,
And that's the problem, because now we have to be on our guard against that laxism where at some point, if that does happen in your case, the petitioner, respondent, yourself have to answer to God one day what you did. So we have to always be aware that this is a potential for abuse, especially when the canons clearly state one witness can provide full proof.
And you might too want to ask, like, even though you wouldn't need to collect all the evidence, you could just ask as a follow-up, would you be able to, do you know of anybody that would corroborate your story there, that knows that, and you can kind of get a feel for
So when we collect the proofs, we do have a couple helpful sheets for you. They're green. Oh, question.
So if they say one of those grounds and there's no one that can collaborate it, we immediately probably should say we need 2 people to verify that you're a trustworthy person of character.
Yeah, I would still try and go for the character witnesses, because you don't want to be caught and made look like a fool. So if you get character witness at the very least, that's going to be beneficial for you. Because there's still once in a while we'll get some of those gotchas. I had a professor in Canada Law School tell a story about how a person came in and said, don't ever contact the respondent in this because he's crazy. And he'll do everything he can to fight this. Don't even contact him. And so the priest was a new canonist. He felt really bad about it. So he didn't contact the respondent in the case. Well, 6 years later, the respondent makes an application for an annulment. And they say, well, we actually annulled your marriage 6 years ago. And the guy said, well, how come I wasn't told? They said, well, we were told you were violent and crazy and would challenge the process. And he says, no, she just doesn't like me. And so you've got to make sure that even somebody who comes in who seems very, very sincere may still be lying to you. So that corroboration is so important. Okay, your shorter process forms are going to be on green paper. And we'll look at the shorter process document form first. That's the single pager. So when that person comes in, you fill out the libellus, and some of the bells start going off that this might be an option for the short process. You're going to say, well, what can we do to find some information about this? And the person says, oh, you can download the arrest record from Iowa courts online. You can get on your computer and tap, 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 tap. There you go. 25 records for alcohol abuse, or alcohol arrests, or domestic abuse, that sort of thing. And you say, okay, this is evidence number 1. And you don't have a case number yet, we'll issue one of those. Then you put document name down there. Respondent's arrest record. The attached document, you staple it. The attached document pertains to the existence of a manifest cause for nullity. If clear evidence of such a cause exists, the petition for declaration of nullity may qualify for a more abbreviated process. This document must be presented before a priest or pastoral minister and duly signed and sealed before being admitted before the court. So you're going to write down that the attached document gives evidence of the following cause for a declaration of nullity. And you would say lack of faith, or any of the usual ones like contrabandum prolis, or against the good of the spouse. And you'll say this document shows that the person had an extensive arrest record during the time they were married. Then the witness who submitted the document signs it, you sign it, date it, stamp it. And that goes in. That's your number 1. You can fill out as many of these as you have evidence for. Basically, in the shorter process, we're looking for 2 things. Then the other one is the shorter process witness form. It's a 2-pager. This is a very much abbreviated witness questionnaire. In the end, you put evidence. This is number 2. Witness name. This is maybe the petitioner's mother who comes in. You make a phone call and say, well, would your mother come down and answer a few brief questions? Sure. So mom comes down, and much the same way, you talk to the person there and say, do you swear to tell the truth, the whole truth, and nothing but the truth? Say yes. How well do you know the parties involved in this case? I've known her since birth. I'm her mother. We've worked together for 40 years, whatever it is. The proposed grounds on which this petition is based are, abuse or contra bono, conjugum, whatever you call it. Do you understand what this means? Yes. Was this circumstance present at the times the parties were wed? Yes. How do you know this? She has black eyes all the time. It's very sad. Then, can you give any examples of how this circumstance affected their courtship or married life? The examples are very, very important. I remember reading a witness statement a while back where we were asking about a particular situation, and the witness said, "Oh, I could give you 100 examples." Signed, Susie. Well, she didn't even give one example. Okay, so we need to have example or a story, something that lends credibility to their statement. Then, is there anything else you'd like to add? Sign it, stamp it. Staple. Well, if there's anything else to go with this, but it's already stapled. And then put that in your packet. Evidence number 1 and evidence number 2, and hand that in to the tribunal. Now, if we look at the petition form, you've got a single page for the more abbreviated process on here, where I specifically list some of the grounds we went over before and the documents that we need. So, you'll see those same grounds that we saw before. I suppose if there was something else that presented itself, you could just write that in. This page after witnesses. Page 4, I guess. Yep, there you go. So you'll check off the grounds that apply there. And then you're going to check off the witness documents and testimony that you're going to submit. So you have sworn statements by the petitioner or the respondent, sworn statements by witnesses, you have character witnesses, medical reports, police reports, prenuptial agreements or other civil documents. Whatever you can turn up is great to go in here. So we want to have 2 pieces of evidence for the shorter process. And then there's the formal request, signed by the petitioner and the respondent. Now, if you can't get a hold of the respondent, but you still want to do this, we'll do our best to contact that person through the tribunal. So we'll work up a short piece of paper with a return envelope that says, "I do not object to using the shorter process." And hopefully if they send that back in, we just proceed right away. We could potentially do that with a phone call. If the person would state, or even an email, that they'll do the short process, that's at least something we can hang our hat on.
Okay. What I'm gathering, Paul, is that if you want to use the abbreviated process, that this needs to be done, and then as well as the form signed by both parties, and then.
Yeah, I'd go and fill out the libellus in total, and then if it looks like you're good with the shorter process, then go back and check off the shorter stuff. Because I'm the only one who can make the final decision to do the shorter process.
Okay.
Because if I don't, then I still need to do the long stuff.
Right.
Hey, Paul, back to the document form there. It just seems to me that your office or the tribunal, that attached document pertains to the existence of a manifest cause for nullity. To me, that's key. I mean, that document needs to be factual, expansive, correct, loaded.
Yeah.
Right? I mean, that's
and
quite...
see, and those do exist. Like if someone, say, has been treated at the VA for PTSD, or if they have, some sort of a statement from their AA counselor that they've been working on alcoholism for 20 years, and those sorts of things. All of that can really be very useful, but it's got to be manifest. I shouldn't have to dig any deeper to find out the facts. It has to be right there.
Thank you.
Thanks, Bob.
Paul, assuming then that it's going to be like, you got a professional figure, that's right privilege that if the enrollment's not important, we're in here, we're going to have to come to the Catholic Church to do it, we just sit down, swear this out, but I'm looking for before the same statement, back to you guys, or
I think if your witness is in another diocese, what we can do is we can send this page to their local priest, and they can do it there.
Local priest can sit down and do.
Yeah, again, this is how they're making the process shorter, is by giving you guys more work. So think of it in terms of those weddings you have where they're doing their formation with you, but they're getting married in Dubuque. You still are supposed to call in their parents and have them sign off of their freedom to marry. Because Dubuque doesn't know who they are, so you need to send in those witness affidavits that state this is what they're about and this is who they are. So this should be some of the process. Now, I try to keep the document as simple and straightforward as possible, so your maximum time with the person should be about 15 minutes, okay? Now, if they have a really great story, maybe you'll want to stay longer. But if it's manifest, you should be able to fill it out very quickly and have it be on the way.
And
But-
a document for premarital pregnancy would be their birth certificate, which would show both parents' names and date of birth.
Oh, the birth certificate, yeah, that's a good idea. So if the birth certificate is billed for 7 months after the wedding, you might say, oh, I see. Okay, the canons do establish several time limits for the hearing of proofs. The problem is that the Latin is a little nebulous, and so is the English translation we're currently working on. This is as close as I think I can get. The initial hearing is to be held within 30 days of the formulation of the doubt. So once I get the libellus, the respondent has 15 days to respond. After that, I determine if it's short process or long process. I do that with the formulation of the doubt. Then within 30 days or so, we can't tell if it's within 30 days or outside of 30 days, but at that 30-day mark, we'll establish a hearing. That 30 days is the time allotted to gather further proof for nullity. So if you couldn't get those documents beforehand, you still have 30 days to try to get them. This is, of course, why it's important to have most of the evidence gathered beforehand. Both parties are allowed to attend this hearing and present their own briefs. So what I'll do is I'll schedule it on October 10th at the tribunal. You can come in and make your case before the judge. If they already have all their evidence gathered, they don't need to be there. And if the petitioner and respondent are coming at the same day, they won't be there at the same time. We'll say petitioner comes at 10:30, respondent comes at 11, or whatever. Following the initial hearing, there's a limit of 15 days to gather evidence in favor of the bond. If somebody's objecting to this whole process, they got 15 days to try and stand up. After this time, I'll take the evidence that's been gathered, write a short cover letter for the bishop. He'll look it over, sign off on his decree. If we do not find that there's sufficient evidence, we'll just remit it to the formal process. Sure, do that.
So it would behoove us, in preparing for a short form, even to have these witnesses and documents forms filled out in advance.
Yeah, so I would try and do the green forms the same time you do the blue form. Yeah.
Paul, how learned do you think the average priest is, knowledgeable is a better word, to make, as we're sitting in our desk, when Mrs. Smith comes in, and you know, all of the above, do you think we are knowledgeable enough to make that decision right there on short versus formal?
No, the only person who actually makes a decision whether it's short or formal is me.
Now, I understand
But you
that.
could say-
I don't mean makes the decision, but leads them to believe it might be.
Yeah, and I think that's probably an area for ongoing training, where we have one of our overnighters or clergy days or something.
Because I sure as heck hate to say to Mrs. Smith, I think this will be a shorter, or you know.
I think hopefully that's, you know, each case is very different, but the really bad ones always have some of the same hallmarks. If there was abuse, if there was drugs and alcohol, if there was a really bad experience of the marriage,
What
that's usually the
about
time it's going to be short.
infidelity
And all that, infidelity only works if it's during consent or
Right.
shortly after.
right,
So, but infidelity 10 or 20 years down the line, not helpful.
right.
When we talk about abuse and abuse, what if it's pricing down the line, it's not put it to a party, it shows up later.
Yeah, again, like if alcohol or drug abuse shows up later in the marriage, that's not a cause for nullity, because we're still going to the moment of consent.
Yeah.
Yeah. But sometimes they can show predisposition for dangerous behavior. Then you're looking at a different sort of ground.
One of the things I don't see listed here, I think as other cultures become prevalent in our society, that it happens now, that I've had a couple of cases submitted because of arranged marriages.
Arranged marriages came up at the last class as well. That the problem with the arranged marriage is that most of them are very successful. I think they have a higher success rate than marriages made out of love, so for lack of a better word. But the arranged marriage, it has to be still proven that there was some lack of understanding, there was a fraud, there was a deceit, there was a condition, there was something involved that still made the consent bad. Because if you grow up and are ingrained of a culture of a predetermined marriage situation, you're giving your complete trust to your parents or to your matchmaker to make a good one. And many people can consent with no problem if they trust the person who's making that match for them. But you have to show that there was some sort of fraud or fear or something involved that vitiated consent.
They didn't want to include that for that reason.
Yeah, because it's not cut and dry.
How about a green card marriage?
If somebody gets married simply for a green card,
You just have to prove that. It's hard to prove.
well, I'm trying. No, you can. I'm trying to think what ground it would fall under. Maybe.
Fraud.
Well, no, because they will know who the person is. It might be some sort of total simulation, where they're not getting married to be married, they're getting married to get civil. So it's this total simulation. Canon 1101. But they're not getting married, they're just getting married to a green card. Any other questions?
Paul, but once again, I'd sure see if you could worm your way into clergy days,
No.
because this is the key.
Well, and it's the biggest change in church law in over 1,000 years.
Is it?
Some of the stuff that they're doing now with how they change how this process can go. The key on the ground will be for you guys to keep the understanding that marriage is still sacred. There's a sacred bond here. There is something that's powerful. But because this process sets the bar so low for annulment, many people might be going around thinking, oh, maybe my marriage is null because I was so foolish when I was 20.
So in your best guess, what do you think percentage-wise of the cases you'll be hearing will be the short process?
If I go back and look at the cases I've decided since I've been sitting on the bench, so to speak, I'd say at least half.
Really? That high?
If the priests are able to get that information into it.
If the respondent signs up.
And if the respondent signs off.
That's the clincher. I don't see 50% because we've got to have a cooperative respondent.
Any advice on what to do with the respondent when they're uncooperative or they still want to argue that they're still married and they're insulted that we're even investigating their marriage? So you occasionally get those, you know.
Well, you know, I mean, we have to deal with unpopular teachings all the time. So as priests, we should be used to talking about abortion or divorce or birth control and sorts of things that are not popular. So when you're dealing with a respondent, it's no different. You're simply stating that this is an opportunity to let your previous spouse move on with their life. This is meant to be a healing process. Just be kind, just be generous. Many times when people are really angry about something, they just want someone to hear that they're angry. And if you just sit there and take it and listen and say, I understand, I'm so sorry, those sorts of things, oftentimes when they're done, they'll say, okay, what do I have to do? They might be I've never experienced somebody who, once we made that contact, wouldn't have anything more to do with us. When they find out that there's a real person on the other end of the line, they'll keep talking. So Beth, you well know the conversions that we see in the respondents sometimes. Complete 180 once they find out that we care about them.
No, most of them usually will follow through with the paperwork, but I've never had much problem with petitioners. It's always seems to be out of the blue. I don't even know about the case, and the respondent will come in and will be upset, and it's trying to talk them, and they almost give you the evidence that there wasn't a marriage to begin with, but they still want to hold on to the fact.
Absolutely, and then when they do that, sit down and write it down. You know, say if the respondent came in and had this long statement with me, and this is what we talked about, that's always very, very handy. And don't be afraid to ask the petitioner to contact the respondent or have a family member. 9 times out of 10, there's still some sort of contact going on with the family or sister-in-law, something like that, to make that contact for them. Even if we have an email, a phone call conversation, a letter, even an angry letter, if you say we can either do the short process, which takes a few months, or the long process takes a year and a half, they might say, well, I'll do it, so I'm not keep getting bothered.
Well, another thing is it's free now, and that would affect, I think, some people who had resentment saying, why do I have to buy this and all?
Right, yeah.
And so that area can remove also.
Yeah, removing the fees, I think, was a great blessing.
They're true.
Yeah, they're talking, bringing up again, the respondent, if they are cooperative, as far as saying, let's go shorter process, that's fine. They, at that point, do not have to participate in the rest of the proceedings.
No, once the respondent consents, they don't need to do anything else. They will still be notified when the hearing is, and their time to offer a brief
But
on
it
their
sure
side.
seems to be less painful on them, quote
Right.
unquote, than
Yeah, there's no lengthy questionnaire or anything like that.
Paul thing. I have to scoot.
Okay, that's fine.
Thank you.
I think I'll turn the mic off at this point. We can have some more questions, though, if that's okay.